Now we're here in case 22 CR 846, State of Ohio versus Jason Murphy. We're here for a probable cause hearing on the state's motion to terminate community control sanctions. Defendant is in court. He's with counsel, Mr. James Matthews. Mr. Matthews, what is the defendant's intention at this time?
Thank you, Your Honor. Mr. Murphy would like to waive both the probable cause and final hearings and a plea of guilty to violations.
Mr. Murphy, you've been charged with violating the conditions of your community control sanctions. Specifically, there are two alleged violations. The first is a Rule 3 violation, which requires you to report at such times and places as directed by your probation officer. And it's alleged that you failed to report as directed to do so on December 19th of 2022 and January 9th of 2023, and quite frankly, thereafter. The next allegation is that you violated Rule 1, which requires you to obey all local, state, and federal laws. And it is alleged that you were cited on March 4th of 2024 by the Cleveland Police Department with failure to comply with an order of signal of a police officer, felony 3rd degree, receiving stolen property of a motor vehicle, felony 4th degree, assault of a police officer, felony 3rd degree, and resisting arrest, a misdemeanor, 2nd degree. You were ultimately convicted on August 27th of 2024 of failure to comply with a signal of a police officer, felony 3rd degree, receiving stolen property of a motor vehicle, felony 4th degree, and assault, felony 4th degree, along with resisting arrest and misdemeanor. Now, you have the right to have a final hearing regarding these allegations, which is a hearing where the state would be required to prove the actual merits of what they're alleging. Now, you could have either or both of these hearings. Well, the probable cause hearing is just a basic hearing initially where the state presents some evidence to suggest you probably committed the offense. You could have either or both of these hearings, but you can also waive the hearings and plead guilty. Your attorney has indicated he believes you want to waive the hearings and plead guilty. Is that correct?
Yes, Your Honor.
Before I can accept that waiver in your plea, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, it could be, make sure I get that right here. Be 6 to 18 months in prison, and that could be consecutive, potentially consecutive to the prison sentence you're currently serving. Do you understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have either of these hearings, or do you want to waive the hearings and plead guilty to the violation?
I'd like to waive my hearings and plead guilty.
Very well, then, as the allegation that you violated Rule 3 by failing to report to your probation officer as directed, what is your plea to that?
Guilty.
And as the allegation that you violated Rule 1 by committing a new offense while on probation, what is your plea to that?
Guilty.
All right, the court will accept your plea of guilty, find that you did violate your community control sanctions. Mr. Matthews, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, thank you. Your Honor, as the court is aware, Mr. Murphy has got a little over 2 years remaining on a 3-year sentence that was imposed out of Cuyotta County. Obviously, terminating community control is going to occur. He would ask, given that he has credit for 120 days on this case, that the court consider running any additional time concurrently with the remainder of his Cuyotta County sentence. Thank you.
Mr. Murphy, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, I just want to say that I was not avoiding my probation officer. I just had a lot of stuff going on with my sick grandma and my son.
You never showed up.
Yeah, because
You never showed up. You got out November of 22, and you never showed up.
I also didn't have a vehicle.
Well, then you shouldn't have said you wanted to be on probation. I could read you the stuff you said. You said, please give me probation. I want to be able to get right back on the track. I'm going to be a good probation. I'm going to do everything right. You never showed up.
I understand that, Your Honor, but I didn't think it was gonna be that hard, but
You never gave it a shot.
I understand that. I know I've been a mistake.
Okay. I interrupted you, so go ahead and, I'm sorry.
I just like to apologize for all the, problems I caused, and I'd just like to take my consequences, Your Honor.
You like what?
I'd like to take my consequences.
Mr. Matthews, anything else?
No, Your Honor.
This court reviewed the pre-sentence report investigation, drug and alcohol evaluation. I considered the facts and circumstances of the offense involved, the nature of the offense involved. Consider what's been said here in court. The defendant's performance on probation. All this is considered only the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, I'm going to incorporate all the findings I made at the time of the original sentencing hearing. With the additional factor today that the defendant did fail to comply with previously imposed sanctions ordered by this court, which is a violation indicating recidivism is more likely. In fact, one of those violations is the fact that he committed new felonies, which doesn't just make recidivism more likely, it actually occurred. At this point, the defendant is currently serving a prison term for new felonies he committed while on probation. He is no longer amenable to available community control sanctions. It's apparent that he never was. Prison is consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that the defendant's community control sanctions be terminated and that the defendant be ordered to serve a term in prison of 16 months. There's credit for 120 days. That term shall be served consecutive to the sentence he's currently serving. Why would I not give consecutive sentence? Why should you get a break for committing new crimes while you're on probation and not serve the sentence for this case?
That's cool, just send me down the road.
I'm sorry?
That's cool, just send me down the road.
Consecutive service is necessary to protect the public from future crime and to punish the offender. They're not disproportionate to the seriousness of his conduct and the danger he poses to the public. And he committed one or more than multiple offenses while he was on community control sanctions. He was on community control sanctions to this court when he committed the new offenses, which is what I'm running this consecutive to. I need to further advise you that upon your release, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another, in this case, 8 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence. At this time, the court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and the defendant's ordered to pay all costs in this action. Mr. Matthews, is there anything else for the record?
No, Your Honor. Thank you.
All rise. In the matter of State of Ohio versus Blaine Snyder, case number 25CR000634, the defendant is present in court with defense counsel Jim Matthews. We are here for purposes of an information hearing. A 2-count information was filed against the defendant on July 16, 2025. Count 1 of that information being aggravated possession of drugs, a felony of the 5th degree with an attached forfeiture specification, and count 2 being misdemeanor theft, a misdemeanor of the 1st degree. It's my understanding today that the defendant wishes to waive his right to have his case presented to a grand jury, and he intends to enter a plea of guilty to both counts in the information, and there is no agreement as to sentencing at this time. Thank you.
Mr. Matthews, does that sound accurate?
It does, Your Honor, and I would like to add one additional thing. Mr. Snyder has now indicated to me that he would like to request a full pre-sentence report as well as a drug and alcohol evaluation.
Okay. Mr. Snyder, are you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, sir.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain in a moment what that means in more detail, and to then go ahead and plead guilty to the 2 charges and information, which I will also review with you to make sure you understand those. We'll then continue the sentencing to a future day to get some evaluations completed, come back on a future day for sentencing where there is no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do today?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. Excuse me. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you can ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
50.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came into court here this morning, have you had any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Nope.
Now, have you received a copy of the information that was filed in this case? That's the document that sets forth the 2 charges you have agreed to plead guilty to?
Yes, sir.
And you had a chance at some point to read that over?
Yes, sir.
Now, in that information, as I said, there's 2 counts. The first count alleges that on or about April 26, 2025, in Madison Village, Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance which contains methamphetamine. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs a felony of the 5th degree. Do you understand what you're charged with in pleading guilty to in count 1?
Yes, sir.
Any questions about it?
No, sir.
Now, the charge also carries with it what we call forfeiture specification, which alleges during the commission of the offense you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal to possess just by the nature of the property itself, like drugs. An instrumentality is some type of property that may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime. You can't use it or possess it for that purpose. And here it's alleged that there was the methamphetamine and any other drugs, along with some paraphernalia and packaging. The whole point of that specification is that you forfeit any ownership interest you have in any of that property. You understand that?
Yes, sir.
Any questions about it?
No, sir.
Now, count 2, what's alleged here, is on or about April 26, 2025, in Madison Village, Lake County, Ohio, that you did knowingly obtain, that you did with purpose to deprive Love's Travel Stops, the owner of certain property, being merchandise, knowingly obtain or exert control over that property without the consent of Love's Travel Stops, who is the owner, or anyone else authorized to give consent. The value of the property was less than $1,000, which makes the offense misdemeanor theft, a misdemeanor of the 1st degree. Do you understand what you're charged with in pleading guilty to in count 2?
Yes, sir.
Any questions about it?
No, sir.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have the right to have this case presented to a grand jury. So that document I just read to you is called an information. and information and criminal charges that are brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately, in secret, for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is some evidence that would suggest the person probably committed a criminal offense. Everyone in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. You have that right as well. But you can give up that right if you desire and go forward in the charge brought by the prosecutor in the information. Your attorney has indicated he believes that's what you want to do. Is that correct?
Yes, sir.
Well, before I can go any further, I need to have you acknowledge that here in open court in writing, and I have in my possession here a one-page document called a waiver of indictment, which sets forth what I've just explained to you about that grand jury process, and that you want to give up that right. Before I can go forward, I need to be assured you understand what that document states and that you sign it here in open court. My understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, sir.
Mr. Matthews, is that accurate? Did you review that with Mr. Snyder, read it over, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did, Your Honor.
Is that correct, Mr. Snyder?
Yes, sir.
So you understand what that document says?
Yes, sir.
Any questions for me about it?
No, sir.
Now, it also appears that you signed the document. Did you, in fact, sign it?
Yes, sir.
And Mr. Matthews, you witnessed that?
I did, Your Honor.
And Ms. Hronik, you as well?
Yes, Your Honor.
All right, I'll make that document part of the record. At this point, I'm going to review with you, Mr. Snyder, all the other rights you have that you're giving up by pleading guilty. And you first of all have a right to a trial. And a trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh out that evidence, and those 12 jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision. Unanimous means all 12 of those jurors would have to agree together, one way or the other, as each charge, whether you were guilty or not guilty. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, sir.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. She would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility, the obligation, she bears the burden to prove you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charges beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, sir.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to do that, or at least in order to try to do that, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. We call that cross-examination. He could ask him anything he wanted to within certain rules. Do you understand that?
Yes, sir.
You understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, force you to get up on the stand and testify, answer questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. You understand that?
Yes, sir.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, sir.
You still want to plead guilty?
Yes, sir.
You understand a guilty plea will be a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court and you'll subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as sentencing goes, you're pleading guilty to, in count one, a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, sir.
Now, count two is a misdemeanor of the 1st degree, which is punishable by a possible term of local incarceration in the county jail of up to 180 days. Do you understand that?
Yes, sir.
Now, if I imposed a prison sentence on the first count, felony charge, any jail time imposed on the misdemeanor charge in count two by law must be served concurrent with the prison sentence. So I'm not permitted to run a jail sentence consecutive to the prison sentence in the same case here. Do you understand that?
Yes, sir.
So your maximum prison sentence you face in this case is 12 months. You understand that?
Yes, sir.
Now, you're currently on probation or parole or supervision to any of the courts or agencies?
Yes, sir.
Were you when this happened?
Yes, sir.
I need to advise you that there could be consequences with that court and that judge as a result of committing a new offense while on probation. Nothing I can do about it or will do about it, but there could be consequences in that court as a result of this. Do you understand that?
Yes, sir.
Do you have any other charges pending against you right now?
No.
You're currently serving a misdemeanor sentence, correct?
Yes, sir.
When is that up?
Next month, I believe September 29th or the 30th.
It's about a month and a half or so.
Yes.
Okay, a little more. Now, if this court were to impose a prison sentence on count one upon your release from prison, you could be placed on what's called post-release control, sometimes referred to as parole. That's a period of supervision you would be on after you served and completed the prison sentence. And in this particular case, it could be up to 2 years. You understand that?
Yes.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. Oh, we're on parole. Never mind. Thank you. I'll get to that in a minute. If you are put on post-release control and you ever violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half, whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just mentioned, there are other sanctions that could be ordered. You could be fined up to $2,500 on count one, be fined up to another $1,000 on count two for a combination of a maximum fine of $3,500. You could be ordered to pay court costs. You could be ordered to reimburse the county for any cost of confinement, community supervision, or treatment. You could also be ordered to pay restitution to any victim for any economic loss any victim may have suffered as a result. Do you understand that?
Yes, sir.
The drug charge also carries with it a possible license suspension of up to 5 years. Do you understand that?
Yes, sir.
And as I mentioned before regarding that forfeiture specification, at the time of sentencing, I will order you forfeit any ownership interest you have in any of the property. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory or required. In this case, you are eligible for probation or what's called community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I would consider that if that's what you were seeking. I'll look at all the information that gets presented, then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be up to 5 years of supervision. And as the judge, I had the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in a Lake County jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
And further, if you are on probation and you ever violated the conditions of your community control, this is what I started saying earlier, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that at that point, again, it could be anywhere from 6 to 12 months on count one, and that could be consecutive to any other prison sentence you may be serving in some other case that may happen or that you're being sentenced to at that time. You understand that?
Yes, sir.
Lastly, when we do go to sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand all that?
Yes, sir.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss the case with your lawyer and have him go over everything with you and answer your questions?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he, or has anyone else for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the plea freely and voluntarily?
Yes, sir.
All right, then, Mr. Snyder, any questions for me at this time regarding anything we've talked about? The rights you're giving up, penalties you face, what you're pleading guilty to, any questions?
No, sir.
You need any more time to talk to your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish if we had a trial. I want you to listen to her and what she says, because I'm going to have some questions for you about that, all right? All right. Ms. Veronica.
Thank you, Your Honor. And prior to going through the facts, I just wanted to make a comment just for accuracy of the record. Technically, the defendant actually is facing pending felony charges out of Madison Township. However, the state has filed a motion for a nollie in those cases, and that should be granted within the next couple of days. I just have a waiver of that nollie, but I just want the record to be accurate that technically those charges still are pending right now.
I appreciate that. The whole reason I would ask that normally is that if you're sentenced to prison on another case before you come back here, I can run a consecutive. That sounds like that's not going to happen since they're dismissing it.
I apologize. I wasn't.
Yeah.
No, that's right.
Okay.
You're good.
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on April 26, 2025 in Madison Village, Lake County, Ohio, the defendant did knowingly possess methamphetamine, a Schedule II controlled substance, and that on that same date, the defendant did, with purpose to deprive Love's Travel Stops of merchandise knowingly obtained or exerted control over that merchandise without the consent of Love's Travel Stop, the owner. Specifically on April 26, 2025, the defendant was subject to a traffic stop due to expired license plates on the vehicle he was driving that were registered to a different vehicle. Upon that traffic stop, it was observed in the vehicle that the defendant had some drug paraphernalia, a glass pipe, and a paper bindle. The defendant also had active warrants at the time. The vehicle was searched, and inside the vehicle, the police officers located a paper bindle with suspected narcotics, a clear vial with suspected narcotics, and several items with the tag still on them sold at Love's Travel Stop, which is where the defendant had just been observed by the police officers coming out of. That merchandise included some women's sundresses, some pocket knives, some charging cords, some sunglasses. Video footage was collected from Love's Travel Stop that did show the defendant taking these items and without paying for them. The value of those items came to $146.91. The suspected narcotics were sent to the Lake County Crime Laboratory for testing, and the paper fold was found to contain 0.24 grams of cocaine, and the glass vial was found to contain 0.47 grams of methamphetamine, Schedule 2. Thank you.
Thank you. So, Mr. Snyder, were you able to hear what the prosecutor had to say regarding what she believes the evidence in this case would show if we did have a trial?
Yes, sir.
And what, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, sir.
Very well, then, regarding count one, charging with aggravated possession of drugs of felony the 5th degree, along with the forfeiture specification, what is your plea to that count?
Guilty.
And as for count two, charging with misdemeanor theft, misdemeanor of the 1st degree, what is your plea to that count?
Guilty.
All right, I have in my possession at this time another document. This is a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just reviewed with you. Before I can accept your plea, I need to make sure you understand this document and you sign it here in open court. My understanding is before I came out here, you had a chance to review that document with your lawyer. Is that correct?
Yes, sir.
Mr. Matthews, did you review that with your client and go over it with him?
Yes, Your Honor.
And did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Snyder?
Yes, sir.
So you understand what that document says?
Yes, sir.
Any questions for me?
No, sir.
Now, it also appears you signed this document. Did you sign it?
Yes, sir.
Mr. Matthews, did you witness that?
Yes, Your Honor.
Ms. Hronik, you as well?
Yes, Your Honor.
All right, very well then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one, aggravated possession of drugs, a felony of the 5th degree, violation of 292511 of the revised code with the forfeiture specification. And count two, misdemeanor theft, a misdemeanor of the 1st degree in violation of 2913.02A1. I will defer sentencing, order pre-sentence report and investigation, drug and alcohol evaluation, and I believe you're requesting the bond be revoked at this time, correct,
We
Mr.
are.
Matthews? I'll revoke bond at this time. Is there anything else for the record, Ms. Hronik? Oh, did I say victim impact statement?
You did not.
Oh, the victim impact statement.
Thank you, Your Honor.
All right.
Nothing else, Your Honor. Thank you.
Mr. Matthews?
Nothing further, Your Honor.
All right, thank you.
All rise.
present in State of Ohio versus Gary Spade on case number 25 CR 654. The defendant is in court represented by counsel. We're here today for purposes of a pretrial. The defendant was indicted in a 2-count indictment filed on June 20th of this year. Count 1 being operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree. Count 2 being also an OVI, a felony of the 4th degree, based on a prior refusal. The state is making an offer for the defendant to plead to count 1. However, I know defense counsel has filed a motion back on, well, I don't have the date here, but they did file a motion to strike or set aside the prior conviction with a memorandum in support with a leave to amend. This is something that the state was aware of prior to indictment. The state does intend on filing a response to this motion.
Okay, when was this motion filed? And I know there was a motion filed requesting to be able to file a motion to suppress outside of the...
They were on the same day, Your Honor. I believe it was the 11th, July. No, that was the arraignment. It was the week after.
You filed the motion requesting to file your motion outside the rule on July 24th.
I guess
There's nothing else in the docket.
you're right, Your Honor. I do not see it on the docket. The state did receive a copy of it from defense counsel.
There's
That
nothing
was
else filed.
my mistake.
The only motion pending right now is a motion requesting to file a motion to suppress outside of Criminal Rule 12Z, which I didn't rule on immediately because I knew we were having this pre-trial, and I'll set that date here now.
Certainly, Judge. I know there was an issue with the electronic filing, and I got a kickback that I didn't do the entry correctly, so I did refile it on that same day. So I would have to check again to see why it didn't go through.
Did you get another thing?
No, I got it that it was accepted.
The same day?
Yeah, because I got it, and then I probably refiled it an hour later. So I'll have to check again and refile again.
So that's a separate motion. You want to file a motion to suppress or make. You want to
Make.
at least have the potential to file a motion to suppress in addition to this other motion.
Correct. The Brooks motion, or the
Right.
motion since I've done
Right.
prior to counsel.
Right. I don't have that then, but okay. What happened here, just briefly?
It was back on St. Patty's Day this year around 10:25 p.m. The defendant was traveling I was traveling on Richmond Street at a high rate of speed. A trooper was also on Richmond Street. He observed the defendant going about 59 miles per hour in a 25 mile per hour zone. He activated his overhead lights and pursued him. He then observed the vehicle go through a light at Richmond Street before stopping his vehicle. Officers performed field sobriety tests on the defendant, determined that he was impaired. The defendant made a few, I guess I would categorize as admissions as well as to drinking on that evening, and as a result, he was arrested for OVI. The defendant does have the 3 prior OVI convictions. One of those is a 2017 conviction out of Painesville Municipal Court. Then he has 2 separate 2023 convictions, one out of the Lake County Court of Common Pleas.
Can you come with me?
Yes, one out of this court, and then another one out of Painesville Municipal Court that he picked up while he was on bond in this
So
court.
the one with me was a misdemeanor?
I'm sorry?
The one with me was a misdemeanor?
Yes, it was a misdemeanor.
It had child endangering charges with
Yes,
that.
an attempted tampering charge, which
That's
was
the
the
felony, okay.
felony that resulted in a prison sentence. Defense counsel in their motion is challenging the 2017 conviction out of Painesville Municipal Court, that was an uncounseled conviction. It does appear that he was uncounseled, at least for that conviction. However, the state is trying to piece together whether that was a knowing, intelligent, voluntary waiver of counsel there, and potentially going to raise a re judicata argument, basically that the defendant could have challenged that prior conviction in any of his 3 prior convictions prior to this one, and so now would not be the time nor place to raise that. However, the state is still researching that issue, and I plan on consulting with our appeals division prior to filing our response.
Okay. So has discovery been provided?
All of the state's discovery has been provided.
All right, Mr. Dysart, so you had the one motion pending, you got the discovery?
I did receive discovery, Your Honor, yes.
Do you anticipate filing a suppression motion, or you have not?
I did want to ask the court that today, based on that, would the court address the other motion first and then a motion to suppress, or how would the court want to handle that? Because I didn't want to file that and then
No, I get it.
two possible settings of.
Well, I mean, I guess the question is, let's just say hypothetically speaking, I agree with you on your motion. That doesn't get rid of the case. You still have a misdemeanor.
Right.
So there's still, issue could still be out there.
Correct.
I guess my question is, are you filing it regardless? I mean, if you're filing it regardless, then you should.
At this point, I've gone through the evidence. I'm going to go through it again probably at the end of this week and decide whether or not. So I know it's still within the.
If it's not, I mean, if the case was going to be had to be dismissed if I ruled in your favor, then I would understand wanting to address that issue first. But if we're going to have to deal with that issue no matter what, you should get it filed. That's my line of thinking there. I will grant your motion to let you file it. How much time would you need?
Until the end of next week would be fine, Your Honor. I believe that the 14th, the Friday of next week.
You can have it filed by then if you're going to file it?
It'll be filed by the 15th if I'm going to file,
All right,
Your Honor.
I'll give you to the 15th and the file motion is pressed.
Thank you.
Is there anything else you would like to? I don't want to argue that motion right now, so we're not going to do that.
No, Your Honor, we
I
have.
appreciate, I mean, just give me a heads up on the legal issues, but I don't want to get into arguing the merits of it. But any other issues you want to raise at this point?
No, Your Honor.
Okay. All right, Mr. Spade, we're in court here today for this pretrial, but we're in open court because you're on an owner cognizance bond. An owner cognizance bond means you didn't have to pay anything. You signed your name, and your signature was your bond. But it also requires you to report at all future court dates. Make sure you appear, I shouldn't say report, appear at all future court dates. And your failure to appear at any future court date is a separate felony in and of itself, which is actually the same level of what you're charged with now. You can get up to 18 months in addition to whatever happens here. So it's obviously important you show up at all future court dates.
I actually didn't know I had court last night, so he texted me. I didn't get anything in the mail or nothing.
Well, you're not. It's going to go to your lawyer, and your lawyer's got to let you know that. So your next court date right now is September 23rd. Now, it sounds like we'll have hearing prior to that with these motions that are getting filed. So you need to make sure you keep in touch with your lawyer and keep up to date as to when your hearings are. We send notices to the lawyers. The lawyers are then responsible for contacting their clients. You can always go online and check to see when hearings are too. And just because if you went online right now and it says your next hearing is 23rd, doesn't mean nothing's gonna get set before that if something gets filed. Your lawyer's talking about filing these motions to try to get some evidence thrown out. If he files that motion, we have to have a hearing on that. That will be before the trial date. Okay? So make sure you keep in touch with him and finding out when these hearings are. Because you need to appear at all future court dates, all right?
Yes, sir.
Right now, as I said, it's September 23rd. If it's going to be a plea, the court needs to know about that 2 weeks before. So that's what, the 9th, September 9th. And if it's going to be a plea, it'll be before the trial date as well. So you need to make sure you find out when those dates are, okay?
Yes, sir.
And you need to make sure you let your client know, obviously.
Absolutely, Judge.
All right, anything else for the record then at this point, Ms.
No, Your Honor, thank you.
Mr. Dysart?
Nothing more, Your Honor.
All right, thanks. You can go. I'm going to write some stuff up here.
Judge. Before you this morning is case number 24 CR 1492, captioned State of Ohio versus Donald E. Wolf II. Judge, on July 14th of 2025, the state filed an information. Contained within that information is one count, that is a charge of operating a vehicle under the influence of alcohol, a drug of abuse, or combination of them, a felony of the 4th degree in violation of ORC 4511-19A1A. The defendant, Donald Wolf, is present today in court with counsel. Mr. Quinn, it is the state's understanding that he is desirous of waiving his right to have his case be presented to the grand jury and plead guilty to the charge outlined in the information and requests a deferral of sentence. And it is the state's further understanding the defense intends to ask for a pre-sentence investigation and a drug and alcohol evaluation. And at this time, the state and the defense do not have a specific agreement to present to the court.
Thank you. Mr. Quinn, does that all sound accurate?
It does, Judge.
And Mr. Wolf, were you able to hear what the prosecutor and your lawyer just represented to the court as to what they believe your plans are here this morning?
I'm sorry, Your Honor, but I understand what's going on.
My question was, were you able to hear what they just said? They just represented to the court what they believe is what you want to do here today. Did you hear that?
Yes, sir. Yes, Your Honor.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'm going to explain in a moment what that means in more detail. And then plead guilty to the charge and the information, which I will also review with you to make sure you understand that. We would then continue the sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here today?
I understand, Your Honor, yes.
Well, then before I can accept your plea, I need to make sure you understand everything we're doing here. I need to make sure you understand. Can you hear me okay?
I'm a little deaf, Your Honor, but yes, I can.
Here, move over here.
No, Stan's got something that'll really help.
Oh, go ahead.
He'll put some...
Wow, okay.
This will be much better. Testing. Can you hear me well?
Yes,
Is that better?
much.
All right, good. So what we're going to do at this point, then, Mr. Wolf, is I'm going to review with you all the rights you have that you're giving up by pleading guilty, all the possible penalties you face. I'm going to ask you a series of questions. If you need anything repeated or clarified when I'm asking the questions, make sure you let me know that. If you want a moment to speak with Mr. Quinn, ask him questions. Again, make sure you let me know that because I need to make sure you understand everything going on here, all right?
Yes, Your
All
Honor.
right. Yeah, good. Well, let's get started then. How old are you, sir?
I'm 73.
Are you able to read and write the English language?
Yes, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
I have no difficulties with that, sir.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
None, Your Honor.
What about in the last 48 hours?
None, Your Honor.
Not even prescribed medication? Nothing?
Nothing, Your Honor.
Okay. Now, did you receive a copy of the information that was filed in this case, which is the document that sets forth the charge you're accused of committing?
Yes.
Yes, Your Honor.
And at some point you had a chance to look that over?
Yes, Your Honor.
Now, in that information, again, you're charged with one count, and what's alleged here and what you're going to be admitting to is on or about December 17th, 2024 in Concord Township, Lake County, Ohio, that you did operate a vehicle while under the influence of alcohol, a drug of abuse, or some combination of them. It's further alleged that you have previously been convicted or pled guilty to 3 or more OVI violations within the last 10 years, specifically in Parma Municipal Court on May 2nd, 2016, also in the Parma Municipal Court on August 29th, 2017, and in the Parma Municipal Court on June 5th, 2019. So that conduct with those prior convictions makes this offense the offense of operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them. And because of those prior convictions, it's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have this case presented to a grand jury. So that document I just read to you is called an information. And what an information is, it's a criminal charge brought by the prosecutor's office without this case having been reviewed previously by a grand jury. Excuse me. Now what a grand jury is made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed a criminal offense. Everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can't give up that right if you desire and go forward in the charge brought by the prosecutor in the information, and your attorney is represented. He believes that's what you want to do. Is that correct?
That's correct, Your Honor.
Well, before I can go any further, I need to make sure you acknowledge that here in open court in writing. And I have with me here a one-page document called a waiver of indictment, which sets forth what I've just reviewed with you about the grand jury and that you want to give that right up. Before I can go any further, I need to be assured you understand what this document says and that you sign it here in court. Now, my understanding is before I came out here, you had a chance to review this one-page document with your lawyer. Is that correct?
That's correct, Your Honor.
Mr. Quinn, is that accurate? Did you review this with Mr. Wolf, go over it with him, answer his questions?
I did, Judge.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Wolf?
Yes, Your
So you
Honor.
understand what this document says?
Yes, Your Honor.
Any questions for me about it?
No, Your Honor.
It also appears that you signed the document. Did you in fact sign it?
Yes, I did, Your Honor.
And Mr. Quinn, did you witness that?
I did, Judge.
Ms. Narodi, you as well?
I did, Your Honor.
Thank you. All right, I'm going to make that document part of the record. At this point, Mr. Wolf, I'm going to review with you all the other rights you have that you give up by pleading guilty, and you first of all have a right to a trial. And a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand that by pleading guilty or giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you'd have the right to have an attorney represent you at that trial. If you could not afford an attorney to represent you at trial, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, I do, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of this charge, and that presumption of innocence sticks with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, I do, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of this charge that I read to you beyond any reasonable doubt before you could ever be found guilty of this charge. Do you understand that?
Yes, I do, Your Honor.
Do you understand that by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
I'm giving up that right, Your Honor.
Now, in order to prove you guilty, if we were going to have a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. he could ask him anything he wanted to within certain rules. You understand that?
Yes, sir. Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that, and you're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And furthermore, if you ever, if we went to trial and you were found guilty of this charge, you have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding this court will enter if your plea is accepted, as well as any other issues that you may raise or challenge up to this point. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor, I understand.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
I do, Your Honor.
Further, as a result of pleading guilty, the effect of that guilty plea is that you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor, I do.
Now, as far as sentencing goes, this OVI offense you're pleading guilty to is a felony of the 4th degree. And this particular offense carries with it a possible term in prison of a minimum of 60 days up to a maximum of 30 months in prison. Do you understand that?
Yes, Your Honor.
So if I impose the prison sentence, now prison's not mandatory, but if I impose the prison sentence, it could be 60 days, and then the next level, if it was going to be more than 60 days, would be 6 months. And then there's increments of every month in between 6 and 30. Do you understand that?
Yes, Your Honor.
So the maximum prison sentence you face is 30 months. Do you understand that?
Yes, I do, Your Honor.
Now, are you currently on probation or parole to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you in any other courts right now?
No, Your Honor.
If a prison sentence were imposed in this case upon your release from prison, you could be placed in what's called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed whatever the prison sentence was. And in this particular case, it's not mandatory, but it could be up to 2 years. That'd be up for the parole authority to determine all that. I don't have any say in that. Do you understand that?
Yes, Your Honor.
Further, if you are on post-release control and you ever violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, in addition to the prison sentence, there are other sanctions that I can order, some I'm required to order. There is a mandatory fine in this case of at least $1,350 that has to be ordered by the court, and I can't waive that. But I could fine you up to $10,500. So a fine of anywhere between $1,350 and $10,500 will be imposed. Do you understand that?
Yes, Your Honor.
There's also a mandatory driver's license suspension of a minimum of 3 years up to a lifetime possible revocation that the court is required to impose. So anywhere in that range. Do you understand that?
I do, Your Honor, yes.
I am also required to forfeit any ownership interest that you have in the vehicle that you are operating at the time of the commission of this offense. I must do that at sentencing. Do you understand that?
I do, Your Honor, yes.
You can also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
I do, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. When I did that, I used the word possible. Prison's not mandatory in this case. You are eligible to be put on probation, what is formally called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, just because you're eligible doesn't mean you'll automatically be put on community control. It means I'll consider that if that's what you're requesting. I'll look at all the information presented, then I'll make the decision I think is the right thing to do. Do you understand that?
Thank you, Your Honor, I do.
Now, if you are put on community control sanctions, it could be for up to 5 years. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions of community control is that you would, if I put you in community control instead of prison, would be that you have to serve at least 60 days of 60 consecutive days of local incarceration in the Lake County Jail. I could sentence you to a full year of local incarceration, but at a minimum, if you're put on community control sanctions, you'll have to serve at least 60 consecutive days in the Lake County Jail. Do you understand that?
Yes, Your Honor.
And then I had the discretion to order a variety of other conditions that I think would be, if I felt they were suitable to helping you be on probation and getting back on track. You understand that?
Yes, Your Honor.
And one thing else I want to advise you of is if I impose a prison sentence, I could impose a prison sentence in that range that I ordered, and then I can also order that upon your completion of that prison sentence that you be put on community control sanctions at that time. Do you understand that? Now, if that was the case, you wouldn't have to do the 60 days because you already did the prison time, but then you could be on community control with the various conditions that the court would order. Do you understand that?
I do, Your Honor.
Okay. Now, if you're on community control and you're violating the conditions of your supervision, we would have a hearing here in court to see if it was called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't already 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. And again, if I did it at that point, it could be up to 30 months in prison. Do you understand that?
Yes, Your Honor. Absolutely.
Lastly, when we do come back here for sentencing, you'll have the right on that day. Say anything you want me to know or consider. Mr. Quinn can be allowed to recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
I do, Your Honor, yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right?
Yes, Your Honor.
Need a moment?
No, I'm good.
The last thing I want to advise you of is that if in the future you ever get arrested for OVI, no matter when it would automatically be a felony of the 3rd degree, which would require mandatory prison sentence be imposed. You understand that?
Yes, Your Honor.
All right, well, do you have any questions about the potential penalties you face or the consequences you face by pleading guilty here today?
I understand, Your Honor.
Any questions for me?
No, Your Honor.
Do you still want to plead guilty at this point?
I do, Your Honor, yes.
Have you had enough time to talk about this case with Mr. Quinn and have him go over everything with you and answer your questions?
I have, Your Honor.
Are you satisfied with his advice and counsel?
I am, Your Honor.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering your plea freely and voluntarily?
I am, Your Honor.
All right. Then do you have any questions for me at this point regarding anything we've just talked about? What you're pleading guilty to, the potential penalties you face, consequences, the rights you're giving up, anything?
I understand, Your Honor. No, I have no questions.
Do you want any more time to speak with Mr. Quinn before we go forward with your actual plea of guilty?
No, Your Honor, I don't think so.
Okay. Then what's going to happen at this time, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we did have a trial. I want you to listen to her, excuse me, because I'm going to ask some follow-up questions for you about that, all right?
Yes, Your Honor.
Wait 1 second, Ms. Naroda. All set? All right, Ms. Naroda?
Thank you, Judge. Your Honor, had the state proceeded to trial in this matter, the state would have brought forth the following facts as evidence. And that was on December 17th of 2024 in Concord Township. The defendant was driving a white Chevy Camaro. The Lake County Sheriff's Department on that date was dispatched to the area of State Route 44 and Girdle Road as a result of an accident. What they learned upon arrival is that Chevy Camaro was involved in an accident that involved 2 other vehicles. The defendant, while operating the Chevy Camaro, had struck a pickup truck, which ultimately rear-ended the car in front of him. A Ford Escape with a family in it. Upon arrival and speaking with the occupants of the truck and the Escape, they learned of the Camaro, and they went and spoke to the defendant at that time. Upon approach, they immediately detected a strong odor of alcohol, an alcoholic beverage, and they made the following observation. At the time when they were interacting with the defendant, he was unsteady on his feet, he had glossy red eyes, and when asked to do field sobriety tests, he couldn't track the instructions and follow them, and they weren't able to complete those at that time. He was placed under arrest for OVI. What they learned while they were speaking with the defendant at State Route 44 in Girdle was that there was a call from the Concord Tavern, and when they responded to the Concord Tavern, they learned that the defendant had been at the Concord Tavern and was asked to leave because he was intoxicated. When he left and was pulling out of the parking lot, he struck a parked vehicle and almost hit some patrons that were outside at the time. And Judge, he does have the prior convictions that were previously outlined by the court.
Thank you. So, Mr. Wolf, were you able to hear what the prosecutor had to say regarding what she believes the facts would establish at a trial if we did have a trial?
I understand what you said, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Yes, Your Honor.
Very well, then, regarding count 1, charging you with operating a vehicle under the influence of alcohol, a drug abuse, or a combination of them, a felony of the 4th degree. What is your plea to that count?
Guilty, Your Honor.
All right, I have with me right now another document. This is 4 pages called a written plea of guilty and judgment entry, which sets forth everything we've just discussed. Before I can accept your plea, I need to make sure you understand this document, that you signed this one here in open court. Now, my understanding is that before I came out here, you had a chance to go over this document with Mr. Quinn as well. Is that correct?
Yes, Your Honor.
Mr. Quinn, is that accurate? Did you review this document as well with Mr. Wolf, read it over to him, answer all his questions?
I did, Judge.
And again, did he indicate to you an understanding of what this document says?
Yes, Your Honor.
Is that correct, Mr. Wolf?
That's correct, Your Honor.
So you understand what this document says?
I do, Your Honor.
Do you have any questions for me about it?
No, I do not, Your Honor.
Now, it also appears that on the last page you signed the document. Did you in fact sign it?
I did, Your Honor.
Mr. Quinn, you witnessed that?
Yes, Your Honor.
And Ms. Naroda, you as well?
I did, Judge.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and did make a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of count 1, operating a vehicle under the influence of alcohol, a drug of abuse, or a combination of them, a felony of the 4th degree, in violation of 4511.19A1A. I will defer sentencing, order pre-sentence report and investigation, drug and alcohol evaluation, there any victim, or you said there was damage or something? I don't know if there's any victim
There was-
impact.
Property damage to the 2 vehicles that were struck on.
What a victim impact statement then, if that's, I don't know if insurance got involved or not, but insurance took care of all that?
Yes,
And there was no injuries or anything? They were just,
not that we're aware of.
all right, then I don't think it's necessary then. So no victim impact statement. Thanks. I'll continue defendant's bond. So what, the bond is 25,000 cash surety or 10%, which was posted with EMHA, correct?
That's correct.
Is there any other conditions? Is Scram still part of this?
Um,
In Scram, right? I thought it was Scram, but you didn't write that on here.
I'm sorry, Judge.
All right. Well, the
Judge-
bond will be continued.
Judge, would the court consider removing the scram? It's been over 9 months. He is in treatment with the VA. He's got some medical issues that he's got to address. And Judge, he's got to put some affairs in order because he's been stuck in this house for the last 9 months. And we know he's going to jail of some type with you. And so over the next 30 days, he'd like to have the opportunity to do that.
So what are you asking?
That the scram be removed, or the EM, whatever it's called.
Well, he's got both.
He has
What do you're wearing one bracelet or 2 bracelets?
One, Your Honor.
The Scram takes care of both, right?
Correct, Your Honor.
I mean, the electronic monitoring, EMHA, I mean, the Scram bracelet just basically tells you if you leave the house. It's not a GPS, so they're not monitoring him everywhere he goes. It's the Scram. I think if you go beyond your mailbox, you lose it, and they know that you've left. So you're asking to get rid of both, basically.
Well, Judge, I don't mind the alcohol monitor at all. He just needs to take care of some things before he gets you.
So you don't mind keeping them Scram on?
No,
Well, I feel comfortable with that. I'm fine with that.
thank you, Your Honor.
I'm gonna. So it's gonna be 25,000 cash surety, 10% with Scram, but I'm not gonna require house arrest.
Thank you, Your Honor.
So the Scram will still obviously monitor any alcohol intake,
Yes,
but I'm not gonna require any longer at this point the house arrest. Was there, unless you wanted to be heard on that, Ms. Naroda, was there a basis for that?
No. What, I don't know what the basis was for the original order for that. The state doesn't have an issue with that as long as the Scram remains, Judge. The only other suggestion I was gonna make is that he be granted privileges to accomplish what he needs to accomplish.
I'm not gonna even worry about that. I mean, that Scram is a normal condition we have with felony DUIs.
Sure.
House arrest really isn't. I don't know what, I'm not being critical of the prior, whatever reason the judge set that for, but I can't see the necessity of that at this point. Scram I like, and that's what we'll keep them.
sure.
So EMHA is off, but Scram is on. I'll call probation. Have you ever had any contact with the probation department? You probably really haven't.
No,
They're the
I
ones that
haven't.
monitor that. They only get involved if there's a violation, so I'm assuming they haven't been involved.
No. there's nothing
But I'll make
about
sure
it.
they know that the house arrest aspect of that is off.
Thank you, Your Honor. We're heading over there anyway.
You're gonna go over there now,
Yeah,
too?
sure.
Do you want me to include that in the change of plea entry as well, Judge? or-
Yeah, I mean, I have a separate entry here setting bond. I'm not gonna say it's continued, I'm gonna say it's reset. Just say bond reset at 25,000 cash surety, 10%, with Scram. That's all I have to say. And if the MHA is not there, then it's off. So what all this means, Mr. Wolf, as far as bond, you just heard what the change is. You're not restricted to house arrest anymore, but you still need to keep the Scram bracelet on.
Thank you.
Again, to monitor alcohol intake. One of the conditions of your bond, again, is no alcohol intake or any other type of drugs. You'll have to submit urine screens if requested by the probation department. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued. You understand that?
Yes, I do.
Now, the whole point of these reports I've ordered is so I could learn more about you before sentencing. And the way the probation department gets the information they need to prepare these reports is they're going to conduct some interviews with you. It's important that when you meet with them that you're open and honest with them because they're going to check and verify everything you tell them. And if they learn you're misleading them in some way, whether it's flat out lying or even not that serious, but maybe embellishing or exaggerating or minimizing something, they're going to let me know that, and I'll consider that sentencing. You understand that?
Yes, I do, Your Honor.
Also, this report is necessary for me to be able to even consider probation as an option at sentencing. Without a pre-sentence report, the law doesn't allow me to put you on community control. And without an interview of you, the probation department can't do the report. So it's important you show up and cooperate with them for that interview so that they can get that, prepare their report. Without that, then I can't even consider probation as an option. You understand that?
Yes, I do.
All right, so as your attorney just said, you're going to leave here now, you're going to go right over to the probation department, fill out some initial paperwork, and get your dates to come back for your meetings with them. So make sure you go over there right when you leave here, all right?
Yes, sir.
All right. Mr. Quinn, anything else?
No, Your Honor.
Ms. Naroda?
Judge, I looked at the Muni Court order, the judge also ordered no driving.
Well,
Well,
I didn't, which, that goes without.
yeah, well, but yeah, put that in there though. I want to make sure a specific condition of no driving so that, it doesn't even require necessarily police involvement. If he's driving and someone sees him, that'd be a violation and doesn't have to get.
We're not driving.
I understand, but I just want to make that clear.
Sure.
So it's a condition of bond, and it doesn't have to be necessarily an arrestable offense that results in the bond being revoked. So no driving as well. Thank you. All right, we're adjourned. Thanks.
All right.
We are here in the case of State of Ohio versus Jeffrey Gallion, case number 25CR285. Defendant is present and represented by defense counsel William Watson. We're here today for a sentencing in the case. Defendant previously pled guilty to failure to comply, a felony of the 4th degree, and operating a vehicle under the influence of alcohol is a misdemeanor of the 1st degree. Since the change of plea date, pre-sentence report and drug and alcohol evaluation have been completed.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. Mr. Gallion is a man who has struggled with alcoholism throughout basically his adult life. I know the court is well aware of his prior history, with this being an overall lifetime 7th OVI. However, technically, for sentencing purposes, it's considered a 2nd and 10, as well as, of course, the felony charge before this court. Mr. Gallion, since the day I met him, is extremely remorseful and ashamed of his actions. He immediately, on his own, started going through treatment. His family's here in support of him. They have been helping him get around, get to work. He has not been driving. He hasn't touched a vehicle. I know the court, I believe, previously granted a release of his truck so it didn't incur any more storage fees, but it's been sitting there. He has been going to work through the help of family. He's been going to meetings. He's been going to treatment. I know the court was provided a whole bunch of letters from various, not only family members, but specifically one from his job, his boss, where he's a very valued employee, works very hard. Your Honor, I know, based upon his history with OVIs, that there's probably little reason for this court to even consider cutting him any type of a break. And Mr. Gallion knows there's mandatory, at least local time, involved in this, not to mention potentially more. But I'm asking the court to consider all of the good that he's done over the course of his life. As you can tell probably by the letters, that he's a very loved person. Mr. Gallion himself tries to do what he can for his family. And obviously, he's a very valued employee at his job. Again, I know he struggled with alcoholism. If the court will consider a community control sanction in this matter, Mr. Gallion has told me he will do whatever this court asks. He's going to show the court that he's very serious about maintaining his sobriety this time. And if the court wants further treatment, Mr. Gallion will tackle it head on. You're going to hear from him in just a moment, Your Honor. Again, I know there's very little reason maybe to grant him a break in this case, but I think due to the fact that he is extremely remorseful, he does realize the seriousness of his actions that day, and the fact that he has taken steps on his own to start addressing things, I'm hoping the court will take those factors into consideration. Thank you, Your Honor.
Mr. Gallion, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. I'm very sorry for what I did. And I know you don't have to give me nothing. You don't have to. You can put me in prison or do what you need to. But I'm trying, sir. And I won't do it again, I promise. I don't. I'm very sorry for what I done. I'm glad I didn't hurt nobody. I'm glad I didn't hurt myself. I don't. All I can ask for is your forgiveness. Whatever you think I deserve to, I have to do. And with that on, that's all I got to say.
All right, thank you, sir. Mr. Watson, anything else?
No, Your Honor.
Mr. Gretzky for the State of Ohio.
Your Honor, the state recommends community control sanctions. Thank you.
This court has reviewed the pre-sentence report and investigation, drug and alcohol evaluation. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I received numerous letters from family members and acquaintances of the defendant. I've read all of them and considered those, I should say. I've considered facts and circumstances of the offense involved, the nature of the offense and the conduct. And I've considered everything said here today. And Mr. Watson, the defendant himself, the prosecutor, all this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. Also consider the factors under 2912, factors indicating the conduct is more or less serious. In this case, the nature of the defendant's driving of that motor vehicle makes it more serious. Fleeing and eluding is just basically not stopping for police when they're trying to pull you over, but the nature of his driving, he was driving, I don't want to state this, but initially clocked going 96 miles an hour on Route 2. Officers then, prior to even the officers activating the lights, he made an attempt to elude the police, went off the road at a high rate of speed, went down an embankment off the roadway, and then got back onto an exit lane for State Route 4. Officers then attempted to pull him over, and he continued fleeing, maintaining a speed of 85 miles an hour. Pickup truck was all over the road, at one point driving directly in the center of State Route 44. And you're lucky you're alive, Mr. Gallion. Lucky you didn't kill anybody else. Ultimately crashed the car into a snowbank. The nature of the driving here makes it more serious than normal. Add to the fact that he was extremely intoxicated. He doesn't remember anything. So you're driving in that manner, extremely intoxicated. That makes it more serious. Makes the fleeing and eluding more serious than normal. Normally the drivers in fleeing and eluding charges aren't under the influence. Nothing makes it less serious. As for recidivism factors, the court finds the defendant does have a history of criminal convictions, albeit aside from the OVIs, the criminal convictions are from 25 to 35 years ago, 4 prior misdemeanor offenses. But as far as OVIs go, this is his 7th OVI conviction. It's not counting the arrest last year that was dismissed. 7 prior convictions for OVI. Now, you obviously have an alcohol problem, but that's not why you're here. You can drink all you want to drink if you want to do that. But you're making the decision to get behind the wheel of the car when you're doing that. You drink all you want to drink, you're putting yourself, it's a risk to yourself. But when you start doing that and getting behind the wheel of a car, you're putting everybody here at risk. And you've done it not once, twice, 3 times, 4 times, 7 times. That's a factor indicating recidivism is more likely. There's obviously an alcohol problem that relates to the offense. Never done anything really to deal with that until just after you got in some alternatives program after the conviction. You've been a daily drinker for years. I will find under factors indicating recidivism is less likely that there appears to be genuine remorse. I will find at this time that the defendant is amenable to an available community control sanction and that prison would not be consistent with the purposes and principles of sentencing. So I'm going to put the defendant on community control sanctions for a period of 2 years. There are going to be consequences, however. I mean, the conduct you engaged in, the fact that your 7th DUI, that's not going to be ignored. That's not going to let you walk out of here. Because you're going to go out and do it again. You say, I'm not going to. You shouldn't make promises like that because you have 7 DUIs. And I'm sure you've said that before after the other DUIs. But the conduct involved deserves to have consequences and punishment. I'm going to order that you serve 75 days in jail. You have credit for 20 you've already served. I'm going to order that during the last 30 days you enter and successfully complete the jail treatment program. Follow all the aftercare recommendations. Further conditions, you're not to use any drugs or alcohol. Must submit random urine screens. They must be negative. A positive screen will be a violation. You're to attend 3 AA meetings a week and have a sponsor. I'm also going to order that after you're released from jail that you be on SCRAM for 6 months. SCRAM monitoring. You are to obtain and maintain full-time employment. I want you to attend grief counseling. You indicated that you think that would be helpful and you never did anything to address the loss of your wife. And very well, that may have something to do with it, but it certainly should be something that you get some help for. And I'm going to order that you get grief counseling. You take all medications as prescribed. Prepare court costs and supervision fees. Now, the jail sentence I ordered is going to be ordered to be served on count 4 only. I'm not ordering any additional jail sentence on count 2, the felony charge. I recognize the credit he has already probably attributes to count 2, but nothing else will. And the reason I'm doing that, quite frankly, Mr. Gillen, I'll be honest with you, I hope it doesn't get to that, but there's more time hanging over your head then on the felony charge if you do mess up. Just so you know that. On both counts carry with it mandatory license suspensions, fleeing and eluding. What was the status of his license at the time this happened? Do you know, Mr. Gretzky?
Just a moment, Your Honor. I do have it.
I mean, it says it's suspended now. Is that because of the refusal?
Yes, that's from the ALS refusal from this case. He was valid before that.
You want-
I was just gonna say, I confirm with my client, at this offense, at the time of the offense, he did have a valid license.
Suspend defendant's driver's license for 4 years on the DUI. 4 years on both counts. I'll run that concurrent. On count 4, to impose a mandatory fine. The minimum is $525. I'll impose the minimum $525 fine on count 4. I'm not going to impose any other fine. I think that covers everything. Mr. Clement, anything else I should be thinking about here?
No, Your Honor, thank you.
I will dismiss the balance of the indictment as agreed upon and release defendant's bond. Mr. Gallen, you understand all the conditions of your probation?
Yes.
Any questions for me?
No, sir.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another crime while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years, I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, that would be 18 months in prison on count 2. And that would be consecutive to another sentence you may be getting sentenced for at that time, or that you're for any prison sentence you may be serving from some other case if that were to happen at that time. You understand that?
Yes.
All right. Mr. Gretzky, is there anything else I should be thinking about? Or I omitted or needs to be addressed?
Other than PRC, no, Your Honor. The possibility of it.
Well, I only don't do that if I don't send them to prison. I only do that when I send them to prison.
Then no.
I don't think I'm
Thank you.
required to do that otherwise. Mr. Watson?
Nothing further, Your Honor.
All rise.
Honor, we're here today in State of Ohio versus Tyron Roper, case number 25CR527. Your Honor, before we get started, Mr. Watson brought to my attention prior to the hearing starting that Mr. Roper's first name, he actually goes by Tyrone, Tyrone. The indictment does not reflect that. So I would ask the court at this time if we could consider amending that to reflect an AKA Tyrone, Tyrone.
I'm not doing that now.
Okay.
No.
With that said, Your Honor, we are here today for a sentencing hearing. Mr. Roper had previously pled guilty to count 1 and 2 of the indictment, a public indecency and a possession of cocaine with forfeiture specifications attached to count 2. The matter is set for a sentencing here today. Mr. Roper is present. He is represented by Mr. Watson. Your Honor, pre-sentence report has been completed prior to sentencing here today. The state is prepared to proceed. Mr. Roper has credit for 50 days of jail time at this point. Thank you, Your Honor.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. The court is well aware Mr. Roper has been to prison before numerous times. For this particular offense, he was released from prison and on PRC when he was caught masturbating in his car, and there was contraband, there were drugs, cocaine found in his car. However, Mr. Roper, as soon as I met him, wanted to take full responsibility for this, did not want to play games, and flat out started telling me some of the issues he's had since he's been released from prison. Most notably, his struggles in trying to find employment based upon his record. Now, obviously, Your Honor, I'm not asking the court to play a violin for my client. He's made his bed in life. He's got to live with it. But on the flip side, he gets out of prison. He's trying to do the right thing. He's trying to do what he's supposed to do. His girlfriend's here in court. My client's been helping to take care of her and her kids. And obviously, he's got some issues with drugs, and he had a breakdown. And he used, he was high when he was caught doing what he was doing. And like I said, he immediately wanted to take responsibility for it. I know, Your Honor, that with just an F5, this court has kind of a wide range of sentencing options. However, I know it's been brought to this court's attention that the fact that my client's on post-release control, that there is an intention, a stated intention from his parole officer to possibly send Mr. Roper back to prison. I'm going to ask the court to consider the fact that hasn't happened yet, that it's possible that when he goes for that hearing, the PRC hearing, that maybe they'll take into consideration what happens here today. Mr. Roper has told me, and you're going to hear from him in just a second, that he wants help. He wants help with drugs, he wants help with his mental health, and he wants help with helping find employment so he can take care of his family. I know, Your Honor, that Mr. Roper does have to, if you will, pull up his pants and deal with life too and take some responsibility and actions on his part. He is prepared to do that. He is simply asking somebody for help. So again, Your Honor, you're going to hear from him in just a minute. I know that potentially he's looking at some prisons in front of him with this PRC violation. I'm asking the court to consider that hasn't happened yet and possibly consider a community control sanction, or in the alternative, Your Honor, if it feels that he's not amenable to that for a minimum sentence. Thank you, Your Honor.
Thank you. Mr. Roper, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
I've been trying my best to help take care of my girl and her kids, and also my other 2 biological kids I got down in Akron going back and forth to court. PRC has been stressful on me. It's been like a dark cloud on me. I own up to my actions. I take full responsibility. The only thing I'm asking is to get help, see if my PRC can get terminated, because
I don't have any authority. If you keep asking me for that. You said that to probation. You've sent me letters. The only way I can terminate post-release control is if I terminate your post-release control and send you to prison for additional time, unrelated, consecutive to whatever I give you in the drug case. That's the only way I have to terminate your post-release control. I don't, it's not my case. How can I just say, oh, he doesn't have to be on parole anymore? I have no authority to do that. Unless I want to give you additional prison sentence consecutive to whatever I would give you on the drug charge. That's the only way I can do that. But go ahead.
But other than that, Your Honor, that's all I have to say.
Okay.
Just willing to just deal with my faith one way and another. Ain't nothing. I ain't saying that what I did was cool, it was okay. Like, I was 100% wrong for what I did. But I'm just asking. I just need help.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Blake for the State of Ohio.
Thank you, Your Honor. The state is recommending prison in this matter, Your Honor. Mr. Roper does have a lengthy criminal history. He has been to prison. It appears on 5 different cases. I know some of those may have been concurrent, but it appears that on 5 different cases he was sentenced to prison. He does have a history of probation violations. He has not responded favorably to previously imposed sanctions when he has been given the opportunity on community control and on post-release control. As the court knows, Mr. Roper was on post-release control when this offense was committed. So it's the state's position at this point that Mr. Roper is not amenable to community control, and we would ask that the court fashion a prison sentence that's appropriate based on the facts and circumstances. Thank you.
Well, this court did review the pre-sentence report and investigation that was completed in this matter. Along with the drug and alcohol evaluation, I've considered the facts and circumstances of the offense involved, the nature of the offense. I've considered everything that's been said here today by Mr. Roper himself, Mr. Watson, the prosecutor, the recommendations. All of this is considered in light of the purposes and principles of felony sentencing, which are set forth in 29-29-11. For the factors in 29-29-12, nothing stands out factually, making it more or less serious. Recidivism factors, however, many of those factors are present. The defendant was on post-release control at the time he committed this offense. He's got a lengthy criminal history. He has served multiple prison terms for multiple cases. He's not responded favorably to previously imposed sanctions. Drug abuse problem that relates to the offense and hasn't addressed it. No factors indicate recidivism is less likely. Under 29-29-13b1, the court notes the defendant has previously served a prison term and was on PRC at the time he committed this offense. That overrides any presumption for community control, permits the court to impose a prison term. Prison is consistent with the purposes and principles of the sentencing, and the defendant's not amenable to any available community control sanctions. Therefore, it will be the sentence of this court that on count 2, the defendant served a term in prison of 10 months. On count 1, he served 60 days in jail. I'll run that concurrent. He has credit for 50 days he's already served. I'm not going to do anything with post-release control violations. So, I mean, I could impose another additional 12 months in prison to be consecutive to what I just ordered. I'm not going to do that. I need to advise you that in this case, upon your release from prison, you could be placed on post-release control. It's not mandatory in this case like it was your other case, however. If you are and you're violating the conditions, the parole authority can return you to prison as punishment for violating the rules for another 5 months, the maximum being 50% of what I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court orders the defendant to pay all costs incurred in this action. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and the balance of the indictment is hereby dismissed. Ms. Blake, is there anything else for the record?
Your Honor, if you didn't say it, just the forfeiture spec attached to count 2.
I did not say that. I'll forfeit contraband and instrumentality set forth in the specification in count 2. Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Thank you.
All right.
We're here today in the state of Ohio versus Larry Wiley. We're here actually in two different cases. The first being 25 CR 463, and we're set for a sentencing hearing. The second being case number 24 CR 533, and we're here for a probation violation. We were last before you on July 11th, and at that time the defendant pled guilty to the lesser included of count 1, that is attempted aggravated possession of drugs, a felony of the 4th degree with a forfeiture specification, and to count 2, possession of cocaine, a felony of the 5th degree with a forfeiture specification. At that time, a pre-sentence report was ordered. That report has since been completed. On the 25-463 case number, the defendant has 75 days of jail time credit, and on that probation violation case, the defendant has 93 days of jail time credit, and there is no agreement as to sentencing. Thank you.
Mr. Watson, any reason not to go forward with sentencing?
No, Your
Well,
Honor.
yes, actually before that, let's deal with the probation, the final hearing first. And then we'll do the sentencing together. That's what I intended to do. So, Mr. Wiley, in 24 CR 533, that's the case that you're on community control sanctions to this court. You have been charged with violating the conditions of your community control sanctions. Specifically, there are 3 alleged violations. The first is a Rule 8 violation, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. And it is alleged that on June 12th of this year, you submitted a urine screen that tested positive for marijuana. You also have charged with a violation of Rule 1, 2 Rule 1 violations, but the first one, Rule 1, first of all, requires you to obey all local, state, and federal laws. There's 2 alleged violations of that. The first one deals with an incident that occurred on March 27th, which is the day that you were arrested for the charges that you pled guilty to in the other case by the Mentor Police Department, and charged with 2 drug charges and a driving under suspension charge. Ultimately, you were convicted of 2 drug charges that are the subject of the other case. The third violation is another Rule 1 violation, which deals with you being arrested by the Beechwood Police Department and charged with domestic violence and criminal damaging in the Shaker Heights Municipal Court. This happened on July 2nd of this year. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to present evidence to prove the actual merits of what they're alleging. Now, you could have this final hearing, but you can also waive the hearing and plead guilty to the violations, and your attorney has indicated he believes that's what you want to do. Is that correct?
Yes.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential penalties you face if you are found to have violated your community control sanctions. If in fact that did occur, the court could extend your probation up to 5 years. It was originally 2 years. I can impose more restrictive sanctions against you, including an order that you serve time in our Lake County Jail, or I could terminate or end your probation and send you to prison. If I did that, it could be a period of 6 to 12 months on count 1, which is what you pled guilty to, in prison, and that could be consecutive to whatever prison sentence, if a prison sentence is imposed in the new case. But 6 to 12 months in prison for that count. You do have, in that case, 93 days of jail time credit. Do you understand the potential penalties you face in this case if you are found to have violated your community control sanctions?
Yes.
Well, having been so advised, then what do you want to do at this time? Do you want to have a final hearing, or do you want to waive the hearing and plead guilty to the violations?
Waive it.
So as to the Rule 8 violation for using marijuana and testing positive on June 12th, what is your plea?
Guilty.
As for the first Rule 1 violation, that deals with the Mentor case for having been arrested and ultimately convicted of the 2 drug charges. What is your plea to that?
Guilty.
Now, on the third one, I'll make it clear here, all you're charged with violating is for being arrested and charged with that crime.
Yes.
So and that's all that this is dealing with. It's
Yes.
not making any admissions. I want to make this clear on the record. You're not making any admissions as to actually being guilty of that or doing that. The violation is simply for being arrested and charged with that.
Okay.
And that's what your admission would be, admitting to that you got arrested and charged with it. No admissions being made towards the actual conduct itself.
Okay.
So in that regard, then what is your plea?
Guilty.
Okay. And again, that's just to being arrested. That's
Okay.
guilty to the violation for being arrested.
Okay.
Strictly all it is. Or the court will accept your plea, find that you did violate your community control sanctions. At this point, it's the court's intention to proceed to sentencing on both cases. Then the one he just pled guilty to the probation violation, as well as the new case 25 CR 463. So in that regard, Mr. Watson, any reason not to proceed to sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'll be brief. I know Mr. Wiley was just here not too long ago. I believe it was October of last year, where he was sentenced on the underlying case where he just had pled guilty to the probation violations too. Was on probation to this court. It's my understanding, at least initially, generally he was doing well, reporting, doing what he needed to do. But ultimately, he picked up yet another drug case, which he has pled guilty to. I know there's been some statements to probation as to his culpability, but I can share with the court that Mr. Wiley has expressed to me that he desires to enter into a treatment program. Now, I know generally when a defendant is given a break once with this court, as he was the last time, that there would be very little reason for this court to consider giving me yet another break. But I'm going to ask the court for just that, to consider Mr. Wiley, to continue him on probation. He has the chance to get into Lake Geauga. How Lake Geauga is handling it now, I know the court's aware, but they don't send any acceptance letters anymore. If the court does continue someone on probation, they will place a defendant on a wait list, and once a bed opens up, he's allowed to be transported there. I'm going to respectfully ask the court to take that into consideration, the fact that Mr. Wiley is receptive to addressing his drug problem and realizing that it's going to require more than just maybe an outpatient or going to some meetings. This would be an intensive inpatient program for at least 30 days. And then, of course, there would be aftercare follow-up after that. Your Honor, Mr. Wiley, I think, is a good person, albeit a bit troubled. And his mother is here in support of him. I've talked to her several times. I mean, she loves her son as most mothers do and wants the best for him. And she also has told me that a treatment program would probably be the best route for Mr. Wiley to help deal with his demons and his problems. So I'm respectfully asking the court to take that under consideration. If the court does not deem, however, that that's appropriate because it's already given him a break, I'm going to respectfully ask the court to fashion a sentence that's reasonable under the circumstances. Thank you, Your Honor.
Mr. Wiley, you have the right to address this court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Yes. Yes, I would like to say, and this is from just being so honest, for the first time in my life, Your Honor, I actually wanted to go to trial, but I was scared to go to trial because of my past history. I felt like I was being charged with something that wasn't even mine, Your Honor. I had a woman write a letter for me stating that it wasn't mine, and for some reason, I'm sorry that the person whose it was a coward and wouldn't bring himself in to address the stuff that was his. So with that, I went ahead and took a plea because I just want to go ahead and get this away from me as far as I possibly can. I'm embarrassed to even be here right now because you did give me leniency and giving me probation and the 60 days that you did give me. But here I am again, here, just willing to do what I need to do to move forward. If I could have treatment, that would be beautiful. But if I can't have treatment, Your Honor, then I understand whatever you have to do is what you have to do. And that's just being 100% honest with you. Thank you.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Ms. Bell for the State of Ohio.
Thank you, Your Honor. The state had the opportunity to review the pre-sentence report in this case, and I was the prosecutor on Mr. Wiley's previous case, and I mean, that really says it all. We were last here for his sentencing on that case in October of last year, where he was given the option to, well, he was sentenced to go to JTP. He completed that program, and here we are again. He was actually on his way to see Mr. Tompkins when he was pulled over on this offense, because he was actively on probation while this occurred. So the state cannot say that Mr. Wiley is a good candidate for community control. So the state would be recommending prison in this case. Thank you.
Thank you. This court has reviewed the original pre-sentence report that was prepared in the 24 CR 533 case, the updated report prepared in the 25 case. I've considered the facts and circumstances of both offenses, the nature of both offenses. I have considered the defendant's time on probation, his performance on probation, the nature of the violations. And I have also considered what's been said here in court by the defendant, his lawyer, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. As for the factors in 2912, as for 24 CR 533, I'm going to incorporate all the findings I made at the time of the original sentencing regarding the seriousness factors and the recidivism factors, with the additional finding that the defendant has failed to comply with the previously imposed sanctions ordered by this court. He was put on probation just in October of last year. He had to do 60 days in jail, so he didn't get out until right before Christmas. And then within a few months, he got violated. So it wasn't that long of a time. But that's a factor indicating recidivism is more likely. In fact, it happened. He committed a new crime. In 25 CR 463, there are no factors indicating the offense is more or less serious. As for recidivism factors, the court finds that the defendant was on community control sanctions to this court at the time he committed that offense. He does have a history of criminal convictions. He has a history of violating his probation. He has not responded favorably in the past to previously imposed sanctions. He has previously served a prison term. There's not any genuine remorse in regards to this offense. In fact, the defendant denies committing this offense. He denied it to the probation department. He denied it here just a few minutes ago. And he was made clear to him at the time of the plea that a plea of guilty means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault. And sure as heck, that's exactly what Mr. Wiley is doing. He's saying that he didn't do it and it's someone else's fault, but he pled guilty. In this court's view, he is guilty, though he doesn't accept the responsibility of that. That's a factor indicating recidivism is more likely. There's no factors indicating that it is less likely. Under 2913B1, and court finds in 25 CR 463 that again the defendant was on community control sanctions to this court at the time he committed this offense. And again, I mentioned this, but I put him on probation just in October. He didn't get out of jail until end of December, and by March he committed a new drug charge, serious drug charge. The amount was significant. He's driving when he's not supposed to be driving. We didn't do anything right then. We held off on that. Didn't violate right away, which we most of the time do. Then you tested positive, so then you got violated, and then you've been arrested on a new charge. This is all within just a few months of being put on probation. You made a statement in your original pre-sentence report that you shouldn't have any problem following the conditions of probation and doing well on probation. You couldn't last a few months on probation. At this point, the court finds that the defendant is not amenable to available community control sanctions and that prison is consistent with the purposes and principles of sentencing. Therefore, in case 24 CR 533, it will be the sentence of this court. Defendant served a term in prison of 7 months. He has credit for 93 days he's already served. In case 25 CR 463, it's the sentence of the court. Defendant served a term in prison on each count of 12 months in prison. I'll run those terms concurrent with each other, but consecutive to the prison term imposed in 24 CR 533. On that particular case, there's 46 days of credit that are solely attributed to that case, and he gets credit for those 46 days. Court finds consecutive service is necessary to protect the public from future crime and to punish the offender. It's not disproportionate. Not disproportionate to the seriousness of conduct and to the danger he poses to the public, and again that he committed the offenses in 25 CR 463 while he was on community control sanctions to this court in 24 CR 533. I need to advise you that in both cases you may be placed on post-release control for up to 2 years upon your release from prison. It's not mandatory. It's up to the parole authority to decide that. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as a part of the sentence at this time. Court will order the forfeiture of the contraband and instrumentality set forth in the specification in 25 CR 463. Defendant's ordered to pay all costs, both cases. And the court disapproves the defendant's placement in front of shock incarceration, intensive prison program, or transfer to transitional control in both cases. Ms. Bell, is there anything else for the record?
Nothing else, Your Honor. Thank you.
Mr. Watson.
Nothing further, Your Honor.
All rise.